Good morning. Today is January 15th, 2026, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan. Every Thursday, along with Natalie, Michael Schwimmer, and David Schraga, I'm delighted to host another cutting-edge webinar for mediators, arbitrators, lawyers, and everybody who negotiates. As you know, there's no charge for these great webinars. Rather, we ask you to contribute to a food bank if you're in a position to do so and you like what you see. One of the best parts of the program, in my mind, every week is when we talk about just how much our generous audiences have contributed to fight food insecurity worldwide in honor of our great speakers since this program began, since this series began in 2020. David Schraga, would you please tell us a little bit about just how generous our audiences have been?
Yeah, thank you very much, Jeff, and welcome everyone to the program today. And thank you to our very gracious and esteemed speaker as well for being here. Our founder and resident bookkeeper, Natalie Armstrong Matan, is in transit at the moment, and we are still tabulating the latest figures. But as of now, we are well into the 900,000s and getting very close to reaching $1 million this year, it looks like. So very exciting. And thank you, everyone, for your continued support.
Thank you, David. And today we're going to have another great presentation by Woody Mosten. Woody and I are old friends. We first met, Woody, I think it's about 35 years ago when our kids played AYSO soccer together in West Los Angeles. That's how we first met each other and became friends. And I was, of course, very quickly impressed with all that you had accomplished up to that point in the world of mediation. You were already a legend, and you've added to that ever since. You've spent your entire career as a tireless peacemaker, working for increased legal access and dispute resolution for underserved and diverse members of our society. Woody Mosten is a professional mediator who helps families, businesses, and organizations resolve disputes. He has mediated conflict involving schools, community boards, churches, and synagogues, and other nonprofit organizations. He is the co-founder of Mosten Mediation Training Academy for online mediation training. Woody is the author of 8 books and numerous articles on mediation and other dispute resolution topics. And if you know anything about family mediation or mediation in general, you are familiar with the living legend Woody Mosten. Woody recently published a book for the ABA, effectively representing clients in family mediation. There's a lot of terrific guidance in there, not only for those representing clients, but for those serving as mediators as well. And we are delighted to have Woody presenting for us today. Woody, please tell us a little bit about the food bank to which you'd like people to contribute if they're in a position to do so. And then on with the presentation, my friend. The floor is yours.
Thanks so much, Jeff. Fighting Hunger San Diego would be my uh, uh, charity of choice. It's a wonderful group that tirelessly tries to deal with food insecurity in my new home in San Diego. Actually, it's La Jolla. It's nice to see so many people, new faces, and many old friends. Jim Malamed and I trained together in 1995, and we've been working together actually on the online, um, uh, the online. What do you call it, Jim? It's the online
Task Force.
task force. Yes, we were co-chairs of that, and believe it or not, it's now 4 years since we published our report, but it's a really good report for all of you in every area of, um, of law and of mediation. Um, I think we're all students here. There are no experts. We're all learning all the time. And one of the things I've so admired about Jeff Kitchaven is he is the consummate student. I can remember back in the early 90s, he used to sit at the front of the room always. In any presentation I gave, he'd wear out his pen taking notes and then ask me questions of things I'd never thought about before. If any of you want to build a practice, you should just follow the ideas of Jeff Kitchen. Jeff tirelessly would get up in the morning, go to sleep at night, never stop trying to promote mediation and his practice. He was the first mediator that I knew of who would advertise, and he had a different print advertisement every week, and everyone knew throughout Southern California about Jeff Kitchen. They didn't know how good he was until they went around his table. And that's the ultimate way, of course, of building any practice.
Well, thank you so much for those kind words, Woody. Thank you.
They're totally meant and heartfelt, Jeff. And what you're doing here continues with it. Today, we're going to talk about one of my favorite subjects. Is you all know I have many, and this is one. And I've always believed that you didn't lose your peacemaker card when you were aligned with one party. The history of mediation actually lives today, and please permit me just to go back into time for a little bit and give a historical update as to how lawyers and mediation have evolved. Because in the beginning, there was a split. I've never understood why there was a split between family and non-family mediation. In civil mediation, mediation was considered part of the litigation process, a late stage event where lawyers brought their clients into mediation because they did not want the ultimate decision over which they could not control, that of a court. And so the parties never knew the mediator before, generally never met the mediator, never saw each other in the mediation, and the mediators were virtually all veteran litigators, many private judges, many like Jeff, and that is the way civil mediation started. Family mediation eschewed the use of lawyers altogether. In a sense, there was a view that the mediator would work with the parties without lawyers. If they needed lawyers, they could go get them, but they were not welcomed. And in fact, most family mediators in the past worked without lawyers altogether. In my own practice, about 50% of the clients come in to my mediations with lawyers. It's a hodgepodge of how they decide whether to use me, because they know my protocols are going to be very, very, very different than retired judges. And we're going to go through some of them today. Once people are in mediation, I find that a high degree of those clients need lawyers to help get through very complex issues of family law. The question is, how do they select those lawyers? And what role will the lawyers play? And so this presentation is intended, I hope we won't upset many of you, but it will lay out a number of new ways of going about it. And I am very open to asking questions or to answering any questions you might have. So I'm going to, what happened to my share? Let's see if we can find it now. There we are. So I want to give kind of an overview of what we'll be talking about today, and then hit some of the highlights and have most of our time with a conversation among all of us. First of all, starting right now, we're going to discuss a redefinition of what the lawyer's role is in mediation. And that starts with another area of my study, and that is of limited scope representation. Because in the old days and the new days today, most lawyers are not trained in mediation. As litigators, they come to the end of the line and then they work the mediation room. But many people can't afford a lawyer, particularly in family work, but I think it's also true in the civil arena that they can do some of the work themselves, but when it comes to mediation, they can use a little help. I have always analyzed, I have a analogy of essentially everybody would love the Mercedes, you know, the Jeff Kitchhaven, the Jim Malamed kind of lawyer. Well, very few of us can afford the Mercedes. What happens is in family work, over 85% of the parties don't have two lawyers, and over 50% only have one lawyer. And so they either they can't afford lawyers or they don't think they can afford lawyers. So bringing in a lawyer at the mediation stage allows for an economic barrier to be overcome where they do not have to be a soup to nuts lawyer. And part of that is that the old word, as I will say, for working in around the mediation room is that this is mediation client advocacy. And I'd like to think that really what we are as lawyers are great coaches. Jeff talked about how we met on the soccer field. Well, we were both coaches for our respective teams. And my daughter was one of the players. And I had a whistle around my neck and a clipboard, but I didn't get on the field to play the game for the girls. They did it themselves. And that is a different role for lawyers in mediation, where they continue to have what the essence of mediation is, client-centered communication, and the lawyers are guides and coaches rather than advocates and players. And so there's a question of whether they're going to be inside the room as the civil mediation lawyers are. Actually, they're not really inside the room. They're in separate silos. When I was teaching at UCLA for about 20 years, for my class, I would bring in consumers who went through the old style mediation, current style, actually, the most popular. And they said, whether they settled the case or not, they never heard what the other party or the other lawyer was saying. There was this magic Svengali person who transmitted the information, the messenger from back and forth. And that was consumer disappointment. And in the mediation protocols I'm going to talk about, everyone can be in the room. And we also talking about using preventive mediation strategies as opposed to avoid and prevent disputes, as opposed to just cure them. And that's the way most of us have been trained. Almost every mediation training is about disputes and not about forming new relationships. And those are business relationships as well as family. Okay. The first thing I would just want to talk about is, as a coach, as a lawyer, representative, the key aspect is try to make it easy for the other side to get into the mediation room. And so I, in my first book in 1995, I had a little mantra. Little did I know there was a movie that would take it over, and it was called Let It Go. And so, in trying to work out the protocols, rather than fighting over every little aspect and trying to get early leverage and power, I started long ago by saying the lawyers really should do whatever they could, short of murder, to get the parties into mediation. Because regardless of which side they were representing, their clients were going to be well better off. One of the things that is not talked about too much is that the current popular style is late stage mediation, meaning lawyers are working, negotiating, developing large bills, and then at the end, the case goes into mediation. The research shows that the earlier the mediation starts, the more effective it can be, and the more malleable and pliable people can be in coming up with an agreement. I think people need to, that we need to let it go when it comes to when it should start. Again, I think that the good mediators can also be good case managers and help get people the information that they need. We don't have to wait till all of the depositions are taken, all the document productions are in. We have the mediator as the ally for the lawyer, help get each lawyer what he or she needs. We also try and reduce the practical barriers. We know how expensive it is. That's why Zoom mediation has become so popular. Virtually all of my mediations, whether I'm serving as the neutral, which is about 60 to 65% of my time, or as the representative of a client, the coach of a client, they're on Zoom. And they are now not limited to one geographical area. Jeff does mediations all over the galaxy, and many of us do, because it's as easy to bring us on in Zoom if the matter is in North Carolina as it is if it is in California. And so if both parties are winning from mediation, I think it's an easier sell. And I think that many of us are learning that now, but some of us are still tied to the old way of late stage. Now, what about in family where most people come in without a lawyer, and many of them don't want a lawyer, or at least one of the parties doesn't want a lawyer, and the other one does? Well, I have found that most people don't know what lawyers do in mediation, how they can help. They don't know how to keep the costs down. They don't know who makes the best lawyers for mediation, and they do not understand how to select them. Now, I'm going to raise my secret sauce right now. I am a card carrying collaborative lawyer, and I'm proud of it. And I have found that many of the traditional lawyers in our field, for whatever reason, think that collaborative lawyers are just less than. I have found that the interdisciplinary team approach of collaborative and the key to collaborative, the attorney disqualification agreement, helps people make settlements without the pressure of the one-day conference. And my mediations, I don't require it because the clients are in charge of this, but I explain that one option for people, and they know it at all, is that the lawyers that they select, if the mediation terminates, that lawyer would be disqualified from representing them in court. Now, the initial view is, oh, I don't want to have to get a new lawyer. I don't want my lawyer abandoning me. If they can understand that by having a disqualification clause, it, number one, prevents the integration of the power and leverage of court while mediation is going on, either by threat or by motions or whatever is going on. And so people are having to face that loaded gun. And before they know it, pardon me, they are in court. But a disqualification clause, no lawyer likes to get fired. If they're going to lose their jobs, if the case terminates, I have found they work that much harder to get a settlement. Now, the second part of this protocol, and by the way, since I started doing this about 15 years ago, my practice has boomed. Not only do I have more people calling me, but I'm making more money because lawyers love this, clients love it. Most people go into mediation having never met the mediator before. Can you imagine going into surgery and not meeting the doctor before the doctor pulls out her scalpel? But it happens every time. Why? Because the lawyers pick the mediator, right? In almost every situation, it's the lawyers who say, look, I like working with David, or I like working with Ed. We trust him or her. But what works for lawyers may not feel so good for their clients. And because there is a sense that what's good for the lawyers is good for the clients. And I have found that is not true. And so I started a new protocol. It's a little like speed dating. And that is bring some potential lawyers into the mediation, have the mediator facilitate a selection process among these lawyers, and have the parties decide two things. Who are the two lawyers going to be that are going to be working in their matter, and who is going to represent, in my situation, husband, and who's going to represent wife, spouse one, spouse two. Because if wife is making a demand in mediation through her lawyer, it's harder for husband to get mad and to vilify the lawyer if he is the one who has selected that lawyer. And lawyers love it. What better way to get work than to give 15 minutes of your time via Zoom to be to get the engagement? So many lawyers like being on the uh, audition list, but to get the part, they've got to get a client to say yes. And so mediators become lawyer work providers. And I find that really very, very helpful. So um, one of the aspects of the protocol is that the mediator provides a list of lawyers with CVs, and the lawyers are willing to participate in the interview selection. And if the parties have agreed, the lawyers are willing to abide by the disqualification clause. There are some lawyers who say, no way, I'm in for a penny and I stay for a pound. And if I'm going to be here, I'm not going to leave if the case doesn't settle. Well, no one puts a gun to the head of a lawyer to work around my mediation table or yours. But I'll tell you, most lawyers want it. And they also know, since privately selected mediation is around the 85 to 90% success rate, why not take the risk? They're going to be there at the end. They're going to be drafting. So it's something to think about. And so what does it look like? So the mediator facilitates an interview of 10 to 30 minutes. The mediator teaches, and I've always thought that mediators are not settlement agents as much as teachers with a curriculum, because clients are not born clients. They don't know much about how to do this kind of work. We can help them. We teach them what kind of questions to ask the potential lawyers. And by the way, we use this protocol to select mental health professionals, to select financial professionals, and other consultants like appraisers and industry experts, to have the clients involved in their own lives. And it's a very low cost way for them to do it. Now, once they are selected, I would make sure that the lawyers get their engagement letters. We try to let them know what the financial arrangements are going to be, so that people make a good, informed consumer choice. And I will make these slides available to anyone who would like them, so you don't have to worry about taking notes now. Jeff, I have a couple more protocols, but I could also stop the slides now and open it up for conversation.
Oh, Woody, we're eager to have your wisdom. Please go ahead.
All right, a couple more, and then we'll spend the last half in conversation. One of the protocols I'd like you to think about is, instead of having the mediator be the sole messenger going back and forth, holding all the cards in her hands and deciding what to share and what not to share, and not knowing the case as well as the lawyers, I have a protocol that lawyers go wild about. And that is, they present the offers, not the mediator. So what happens that instead of it being like a Kissinger shuttle, where the Palestinians were told one thing and the Israelis were told another, and I don't think most mediators do that, but it may be around the edges. Party one's attorney makes the proposal to party two and her lawyer directly in their room with the help of the mediator. There's a whole protocol where you prepare people to listen, ask questions, but don't respond yet. Have an educational session where you really learn what's on the other party's mind directly. Now, you say, well, how does that differ from just a joint session where everybody's in the room? Well, if the husband's attorney is making the proposal, husband does not come in the room. And one of the reasons is there's often a emotional reaction between the parties and a devaluation when both parties are there. But when the attorney comes alone and has a chance to speak directly to wife or to the other party, it's a totally different kind of conversation. And it's a very productive one in many, many situations. So I'm not going to, I do whole trainings on this. So I'm just raising this as a protocol. One of the last things I'm going to talk about are creative ways for us to close the mediation. As most of us who've done any litigation know, that when there's a settlement and it's presented to a judge, the judge go ask questions of both sides. It's called the voir dire of the parties, and the parties say yes, I understand this. I understand that I can't come back for spousal support ever again. I understand that these issues are being reserved and not being dealt with now. It's a summary of the agreement, and then the judge says, "I'm satisfied that everybody's understanding it, and I'll sign off." Without having to go to court, mediators who have this kind of closing, I find, is well received by their lawyers and well received by the parties. It's well received by the lawyers because, remember, in California at least, and in some states, there's mediator immunity or quasi-immunity, and the mediators aren't going to be sued, but the lawyers have pretty deep pockets, and the lawyers want to make sure that they can protect that possibility from happening. These kind of closings with Zoom recordings and Zoom transcripts, and sometimes I bring in a private judge who can actually decide status of the divorce at the same time. It's a very popular protocol, but that is only half of the closing idea. The other half, the more peacemaking half, is for the parties to be able to have a moment to talk with each other. It's the last thing that most lawyers consider wanting to happen. But remember, it's been signed. They're not going to undo the deal. The way most people finish a mediation is there'll be a reluctant handshake, a air kiss, maybe some people don't even see each other. They walk out the other door. This is a chance to actually talk about what happened, to maybe have some apologies for behavior that they may not be so proud of. Maybe to invite children or other members of the family to be able to be part of it, because a divorcing couple and their children are part of a bigger system. And sometimes it's promises and aspirations for the future. And I have found that parties that work with me do not have to have this kind of a closing, but those that do, the lawyers love it and the clients seem to like it as well. So as we go into questions, these are some of the books um, that Jeff mentioned. All of them have a peacemaker theme. See the one on the left, the big green one? That is the book that I wrote starting in 1994 that Jeff actually contributed to in ideas and gave me a lot of help, and for which I will always be grateful. Um, and the new one, which, by the way, if you're looking for a rising star in the field, Laura Traum of New York is that person. And the book, Family Lawyer is Peacemaker, is being released this month. And I'll just, I won't go through all of the chapters. I'll just let you take a look at some of them. By the way, I don't sell books anymore. I used to be like a Fuller Brush salesperson and carry a whole box of books wherever I went. I don't do it. You can get them directly from Amazon or from the ABA. The chapter by Judge Elizabeth Potter Scully is just nothing short of brilliant of how judges can be peacemakers. So, Jeff, I turn it over to you, and I'm willing to answer any questions people have.
Thank you, Woody. That was just terrific. Let me start with an observation and then a question picking up on Jim Malamit's comment in the chat. The observation is that we've had on the webinar over the past couple of years a number of general counsel of Fortune 500 companies, general counsel of Microsoft and other prestigious companies. And they all say pretty much the same thing, which is they're not crazy about mediating on Zoom. They want to mediate in person and they want to look each other in the eye. They do not want caucus only mediation. And a number of our regular listeners, people who listen to those episodes of the New Possibilities Hour, were smiling. I was smiling to hear that this paradigm of the caucus only model where people never lay eyes on each other is heartily rejected by the general counsel who sit, in a sense, at the very top of the pyramid of users of mediation. So I think that while I agree with you, Woody, that there is this rut, this routine that many mediations seem to devolve into, where the parties never lay eyes on each other, there's no direct communication. You lose so much in that process, although there are occasionally times when the level of antagonism is so high that you really can't let people in the same room with each other, but that's far fewer than I think most of us assume. So let me just uh, plant in your mind the seed that perhaps there's a comeback for in the wings for the kind of mediation that you and I and others understand has so much to offer in terms of enriching the humanity and the experience of getting conflicts resolved. And the question, picking up on what Jim mentioned in the comments, is what about artificial intelligence? It seems to be taking the world by storm. I know I use it and pose all kinds of queries to AI pretty much every day. Others do too. Have you experimented with the use of artificial intelligence in your mediation practice, and what has worked well and what has worked not so well?
I have to tell you, I'm a horse and buggy mediator. Um, I haven't. Uh, Maybe it's my reluctance or fear from going into the AI field, um, uh, and maybe it's just the old way that I've done it. I am not the right one to answer that. I have not brought it in to my practice. My training partner, Susan Guthrie, clearly has, and she's um, uh, been a popular presenter for good reason. And I know Jim is an expert in it. So I'd turn it back to Jim or others if you want to talk about that, but I can't be of much help.
So there continue to be new frontiers for all of us. Woody, why do you think that there's this cleavage between family mediation and civil or commercial mediation, where people who potentially have so much to learn from each other really don't talk to each other that much? Why do you think that is, and what do you think we can do to increase our learning by learning from each other better?
One, I think, is we should learn together and train together. Um, One of the things in my trainings that has become much more popular is that um, several mediators or lawyers who work together take the course together. So they're working and they're learning similar kinds of protocols and strategies. Um, it's what other fields do. In the medical field, you wouldn't want the surgeon and her nurse to try the first time in the operating theater, right? You'd want them to have practiced before, and that's the way they do it, but not in the areas of negotiation and mediation. There are a lot of lone rangers, so that's one reason. The other reason is we for whatever reason we have different organizations which are unidimensional. Family mediators and family lawyers believe that their universe does not include the civil, so their conferences attract family oriented professionals, and the same is true for civil litigators and um, and their conferences. So they're not learning together. Um, I think there is no reason why civil and family should be so different in the protocols and the way it's approached. Human beings are human beings. Conflict is conflict, whether it's in a company or it's within a family. And so many of the things that I try to bring in, I have trained outside of family and I try to bring it in. And it sometimes is well received, and sometimes the it's not what the traditional family lawyers are used to or like. Remember, family lawyers select the judges that they like to be their mediators because they are comfortable. They're comfortable with a judge that pushes them around, and they're comfortable with a judge that has trial experience as opposed to negotiation expertise that people can learn outside of the litigation world. I mean, uh, it's the whole thing of, does someone need to carry water for a litigator 5 to 10 years after law school before she becomes a mediator? And my view is, take those 10 years and be a mediator straight out. You'll have with the right kind of training and the right kind of mentoring um, and low cost and hourly rates, um, these people can build a practice and provide services where um, Jeff, you and I will outprice many middle income people. They just couldn't afford us or choose not to afford us. And I think we need a much greater range of mediators. And they can
So,
learn those, both civil and family. It isn't all that different. There are substantive differences. For example, I'm a family law specialist. I had to take a 50-hour course. That's not so difficult to do. And over time, a good mediator can do both civil and family, in my view.
so Woody, you referred to a stereotype of mediators, the judicial model, and it's not just retired judges who practice that way. There are some lawyers and even perhaps non-lawyers who practice in that style, and you talked about pushing people around. And particularly when those people are represented by lawyers of some sophistication always, I've never really understood why lawyers put up with getting pushed around by any mediator who doesn't know the case as well, right? The lawyers have learned about the case over months or perhaps years. Mediator finds out about the case a week or two when we get briefs. Lawyers know their clients presumably very well, and we don't know their clients at all, generally speaking, when they come to the mediation. Uh, why do you think it is that so many lawyers are willing to subject themselves to that kind of conduct and feeding into that stereotype which has arisen?
Well, we start with the paper chase model, and it comes in through our career. There is kind of a view that the client is the problem, and uh, many people, and you all know this, lawyers bring a case into mediation often when they're not getting paid, or when the client isn't doing what the lawyer has advised, and they need some support. I mean, I actually consider one of the jobs that I have as a mediator is supporting um, every participant in the mediation, which includes the lawyers who um, have a lot to say and need um, maybe some support for the client, with the client. I think that lawyers believe that if, in fact, they get a judge who finds the holes in the case, either side of the case, who can predict what will happen, the evaluative prognosticator, that is going to settle the case, because the parties, through negotiation and through beating each other up in litigation, haven't done it to that point. It's a late stage. That's another reason that there isn't the patience to go through a negotiation. Um, Len Riskin and Nancy Welch wrote a wonderful article, and I know you're aware of it as well as many of the people here. It's called "Is That All There Is?" And in that article, he looked at this isn't family, this was civil mediation. And he found the conversations to be rather myopic, that they were narrow. They were only talking about the, the strength of the case. Why? There were two lawyers, and the lawyers liked that. There was a judge, there was a mediator, generally a lawyer, and the mediator liked it. And the clients were kind of told to shut up because they hadn't done so well up to this point. And so instead of discussing how a um, a settlement, a conflict can be an opportunity for a readjustment of a business or business practices, or of how to increase um, um, profits, how to keep employees um, uh, from leaving or from suing, from using a preventive approach. The mediation devolves totally into a curative kind of settlement only discussion. It's as if every knee injury required a surgery as opposed going to rehab. And so lawyers aren't much for the rehab for their clients. They want a deal. And that's why the the model of the conference, and I notice many of the people in this room charge by the day because they give a day and there's an expectation that there should be a deal at the end of the day or we'll get another day. As opposed to sequential mediation, which is the heart of family, where there's not an expectation there's going to be a settlement in the day, but it's built. There's building agreements as opposed to knocking out a settlement. So that's maybe a long answer to your very important question.
So, well, look, Woody, it's very helpful and it leads to the next question, which is, are there things that mediators can do to try to enrich the kinds of deals that people make in our mediations? And if there are those tools, should we use them? After all, if people come to us and they're not interested in a gourmet dinner, they're just interested in a fast food cheeseburger, who are we to tell them that, you'd really be happier with Chateaubriand?
Well, how many of us have had real late night mediations, right? Where almost to the dawn of the next day,
Oh, yes.
uh, right? Well,
Yes.
and one of the reasons for that is the view that the lawyers mostly, but also the mediator, believe that if we don't get the settlement now, we won't get it at all, and people will walk away and they won't deal with it. I wrote an article which is available called Late Nights and Settlement Rights. And it was written um, with a judge and actually two judges now because Judge Elizabeth Potter Scully um, was one of the co-authors. And we basically said, look, when people get tired and um, overwhelmed, they might settle, but they may not want to stay with it later. They may stay with it because having to try to get out of it is is really hard. But in California, for example, how many cases do we have of mediations that settled and then people didn't like the settlement and they went to the appellate courts and the Supreme Court? There are over 25 of those cases. I got a list of them. Many of you, I'm sure, know about them. And so instead of it being over and they get their quick burger, it lasts forever. And so I would rather, and people know that this is my view, I will never pressure someone to stay late. I will often uh, tell them, okay, there's a little bit of distance right now. We'll come back. Yes, it may be a week or two. And if you don't want to stay where you were, you don't have to. And if you change your mind, you can, but it's your life. And instead of feeling like it's settle now or forever hold your peace, build an agreement that's built on sand, that's not built on sand, that has deep roots. And I find that people live with it a lot better. And that's why the kind of protocol of the closing comes in as well. So there's informed consent at the closing uh, in addition. How many times have all of us been at the end of one of these horrible long days where there's a draft and there's writing all over it? People really don't know what it is, the consequences of what they're agreeing to on some of the biggest issues of their lives. And so one way is just get the deal and they'll live with it. And that has been the view traditionally in my experience. I think family mediators have a much more informed consent view, and I try to bring that in to all the mediations that I work with.
What's interesting, Woody, that perhaps part of that is when the parties are not represented by counsel, as is more commonly the case in family mediation, perhaps there's a greater responsibility on the mediator to procure or guarantee that informed consent. Whereas in the civil and commercial cases where people are almost always represented by lawyers, we rely on the lawyers to make sure that there is the buffer, the insulation, the insurance to make sure that informed consent is given and that the clients are not being unduly bullied or pressured into doing things. We
Well,
have, go ahead.
let me just say something, Jeff. My experience has not always been that the lawyers give the informed consent. I think they should, but quite often everybody's so tired. And I don't mean just from one day. I mean from a a system that has been capturing them for years. And they want it over. And there's a lot of pressure to get it over. And instead of taking the time, um, quite often, and this is another subject, but we don't have time for it today, of requiring a second opinion before a mediation agreement is agreed upon, where the representative of the client says, "Look, there was a lot of movement today. There was a lot of moving pieces. Let's get somebody else in." Because remember, a lot of the lawyers are solo practitioners and they don't have a deep bench. It's nice, I think, to get somebody else to take a look at it. Well, that's against the culture of getting a settlement at the end of the day and living with it. And I think there's room for both. And so this is a big issue for conversation.
Fair enough. We have just a minute left. Jim Malamed, I saw in the text you have an offer to make to Woody if you'd like to say it out loud and any question or comment observation. You're such a pro in this area, family mediation particularly, and last week you were our guest. We'll give you the last word.
Well, just a comment, Woody, is for decades now, you've really been both coach and team leader as a mediator, helping the group to do the best they can. Uh, for folks, particularly that really can't afford expert advice, do take a look at AI. It's really rather fascinating, dramatically improved of late. And as an idea generator, that in fact brings ideas to the mediation, not through the mediator's mouth, but intriguingly from other sources. I really do believe it's a special opportunity for the field of mediation to embrace AI as a means of further empowering participants and their information base. Nothing changes the fact that they completely control all the decision making. And I also believe for pursuing optimized solutions. Just as an example, you can ask AI what has worked for similarly situated parties in other circumstances, and you'll get robust answers. And it can be a real idea generator. So I want to give you a free 1 hour AI utilization course, Woody, anytime you want it.
I'll take you up on it, Jim.
That's a fabulous offer and a fabulous collaborative way to end a conversation with the ultimate collaborative lawyer and mediator, Forrest Woody Mosten. Woody, this could go on for a long time. Thank you so much. This has been a wonderful hour. I know that I'll be contributing to Feeding San Diego in your honor, and I know that many other people who watch this live today and also watch the video replay will also be contributing to Food Bank in your honor, and that's really what it's all about. Woody Moston, thank you so much for being our guest here on the New Possibilities Hour. Wonderful presentation. And with that, we are complete.